Hello, good afternoon friends. Welcome. My name is Vaibhav and today we will be learning about criminal law. So let us decipher the two words, criminal and law. What is law? Now simply understood, law is the command of the sovereign. Now what sovereign for a democratic country like India, what the government which represents the people say becomes the law. Or for in a country where monarchy is the law, or where monarchical system is followed, there what the monarch says becomes the law. For example, England. So, law basically lays down our conducts or regulates our behavior in the society. What we ought to do, what we ought not to do. This is what law tells us. Various jurisprudential authors of criminal law have categorized criminal law or have kept criminal law under public law system. Why? Because a crime might be committed against you or me, but the repercussions of a crime is felt by the entire society. So it is the public as a whole which suffers because of the crime or the deviant behavior of one person. That is why criminal law comes under the public law system. Now we can divide law under three heads. Let us keep constitution as a separate part, which is the supreme law, from which all other laws comes into existence. Then there is civil law, and then there is criminal law. Civil laws are those laws which determines your rights and liabilities, and which do not prescribe for any penal punishment. The basic difference between civil and criminal law is this: that whereas in criminal law, the punishment prescribed, there is a punishment, there is a penal punishment. So if you beat someone or if you cause hurt to someone, then you can be penalized, or you can be sent to imprisonment for a maximum of 1 year, as that has been prescribed under IPC. Various examples of criminal law could be the Juvenile Justice Act, the Prevention of Children from Sexual Offences Act, or Arms Act, the Indian Penal Code itself. These are different examples of the statutes which are, or the laws under criminal law system. Now, what is crime? Now, in order to understand crime, there are four essentials of a crime. There must be an act or omission. Now, act here is a physical act. Omission here means there is a duty which has been cast upon you and you fail to, or you omit to do that duty. So that is omission. Such act or omission should be prohibited by the law. So what I am doing, in order to become a crime, if I commit an act, if I do an act, that act should also be prohibited by law. Must be injurious to the public. It must be injurious to someone because my act should cause injury to someone else, and it should be punishable. There must be some punishment. So these are the four elements which constitutes crime. Now, injurious to the public, you might ask as to whether we need to see whether it is causing injury to the public as a whole or not. But since we discussed that under criminal law, a criminal act is an act against the entire society. So it is not necessary that in each and every offence we need to see whether it is causing injury to the public or not, because this injury to the public is presumed in most of the offences, that such act would cause injury to the public, and there has to be a punishment which is prescribed for it, a penal punishment which is prescribed. Then only we can say that it is a crime or something is a crime. So let take an example of hurt. Under section 319 of Indian Penal Code, hurt has been defined as if any person causes bodily pain, injury or disease or infirmity to someone else, to another person, such person is said to have caused hurt. So for example, if I slap someone with an intention of slapping him or causing him hurt, then my act, since there's an act, it is prohibited by law, that is under section 319 of IPC. It is injurious to someone else, and there is a punishment of 1 year, maximum of 1 year which has been prescribed. That is why it becomes a crime. And all those acts which have been given or which has been categorized under IPC are criminal acts. So now a very important aspect of crime is that crime is neither static, which means that crime changes. Crime changes from place to place, and crime also changes from time to time. What may have been a crime few years back is not a crime anymore, or what is a crime in India might not be a crime in England. Example of this could be sati. Previously sati was a very accepted practice, but now we have a separate legislation in that regard prohibiting sati. Gay marriages in India is prohibited, whereas in England it is not a criminal offence. So criminal law changes. It is not static, it never keeps the same. Now criminal law in India can be categorized into two heads again. One is the procedural law and the other is the substantive law. A substantive law means that law which lays down the definitions as to what all acts constitutes crime. The basic example is the Indian Penal Code. That is a substantive law which gives the definition of murder or hurt or grievous hurt, the categories of offences. That is the substantive part. And the procedural part is as to how would we prove these offences in a court of law, how the criminal justice system would be set into motion, as to how would we approach the court or how would we approach the public authorities like police. So these are the things which are given in the procedural law, the procedural aspects. That is the procedural part. As to criminal liability, there are two elements under criminal liability. One is, in order to impute liability upon someone, we firstly need to see two things. Actus reus and the mens rea. Now, actus reus is the physical element. My physical movement is my actus reus, the way I act. So if I move my hand in order to strike someone, the movement of my hand is my actus reus. Now, in criminal law, you cannot fasten criminal liability only because of the physical movement. There has to be some mental element attached to your physical movement in order to impute liability. So, mens rea, on the other hand, is my mental element. The mental element here, as to what was my mental setup when I moved my hand, because I might move my hand like this, I might swing my hand and someone comes in between the movement of my hand and he gets slapped, but I never intended to hit him, right? So only because of my physical element, only because of my physical movement, I cannot be criminally liable, but there has to be some mental element. Now under mental element again comes three portions. One is volition. Volition is your movement with your free will, which is quite similar to that of actus reus. if I'm raising my hands from here to here, it is because of my free will that I'm doing it. Nobody has put a gun on my head and asked me to move my hand. I'm doing this because of my free will. That is my volition. Then there is motive. Motive is the reason why I do the act. Why am I doing this act? Or why did I slap someone? I might slap someone because I wanted to take revenge, because he had, prior to that incident, he had hit me, basically I wanted to take revenge from him because of any circumstances. Or my motive might be to take something which I think is righteously mine. So that is my motive, why I do the act. And the third is intention. Intention is the consequence which I seek to achieve. Now, in common parlance, motive and intention are considered to be the same thing, or we tend to in normal parlance, what we do is we understand motive and intention to be quite similar. However, they are not, because in intention, I'm seeking certain consequence. Now, what would be my consequence when I hit someone? The consequence which I'm seeking is that particular person whom I'm hitting experiences some pain. So that is my intention here. Whereas motive is because I wanted to take revenge from that person. So, although intention at all the times is very difficult to prove in a court, motive does help in proving intention. So, this is how these elements, the actus reus and the mens rea, generally determines how and whether criminal liability can be imputed upon some person or not.